Hello everyone and welcome to our pre-recorded webinar, Understanding COBRA. My name is Nicole Smith and I'm the Benefits Education Specialist here at Flex. I oversee all of our educational efforts for insurance producers, plan administrators, and plan participants. Today we're going to be covering the basics of COBRA, including qualified beneficiaries and qualifying events, required notices, and the COBRA election process. I'll also take a few minutes at the end to tell you a little bit about COBRA administration from Flex. So what exactly is COBRA anyway? The Consolidated Omnibus Budget Reconciliation Act, or COBRA for short, is a federal law that became effective on April 7, 1986. This law requires covered employers to provide qualified beneficiaries with health care continuation coverage. COBRA was originally conceived as a way to prevent job lock. Before COBRA, employees were often hesitant to leave a job due to the loss of health insurance. So, which employers are subject to COBRA? Any employer with 20 or more full-time equivalent employees on more than 50% of working days the prior year. COBRA applies to both private sector employers and local and state governments, but it does not apply to the federal government and certain religious organizations. COBRA only applies to employer-sponsored health plans, which includes HMOs, PPOs, and high-deductible health plans. It also applies to dental and vision plans, health reimbursement arrangements, and flexible spending accounts that have been underspent, meaning that the employee has contributed more through payroll deductions than he's been reimbursed from the plan. COBRA does not apply to group life insurance, short or long-term disability, or health savings accounts. Employers who do not comply with COBRA are subject to penalties, which can be as high as $110 per violation per day. Even more, employers can also be on the hook for claims not covered by the carrier if they do not satisfy their COBRA responsibilities. Next up, let's talk about qualified beneficiaries and qualifying events. A qualified beneficiary, or QB, is an individual covered on the group health plan on the day prior to a qualifying event. This includes the employee's federally recognized spouse, both same-sex and opposite sex, and the employee's dependent children. A qualifying event is an event that causes a qualified beneficiary to lose group health coverage. The type of event and the QB who is impacted will determine the maximum length of time that COBRA must be offered. Here we've got a chart showing the different types of qualifying events and the length of COBRA associated with each. For a voluntary or involuntary termination of employment, for reasons other than gross misconduct, the employee, spouse, and dependent are each entitled to 18 months of COBRA coverage. They would also be entitled to 18 months if the loss of coverage is due to reduction of hours. If the spouse or dependent child lose coverage due to the employee's entitlement to Medicare, then they are both entitled to 36 months of COBRA coverage. Keep in mind, it is not a qualifying event if the employee voluntarily terminates coverage to go on Medicare, only if the employer forces the employee off the group health plan once they become entitled to Medicare. In the case of a divorce or separation, both the spouse and dependent children would be entitled to 36 months of COBRA as well. One note here is that the dependent children wouldn't have to elect COBRA, as they could stay on the plan with the employee. If the employee were to die, then the spouse and dependent children would be entitled to 36 months of COBRA coverage. Lastly, if a child loses dependent status under the plan, then the child would be entitled to 36 months of coverage in this situation as well. COBRA regulations require that employers provide certain notices to employees and qualified beneficiaries. The first notice is called the general notice or initial notice. This must be provided to employees and their covered spouses within 90 days of enrolling for coverage. This notice informs covered employees of their rights and obligations under COBRA. Due to ACA regulations, this notice must now include information about alternative coverage options available through the health insurance marketplace. The Department of Labor released model language for this update back in 2014. Probably the most important notice is the COBRA election notice. This notice must be provided within 14 days of receiving notice of the qualifying event, and it informs QBs of the qualifying event, the date coverage was lost, how to elect COBRA, the COBRA premium amount, and payment procedures. This notice must now include information about alternative coverage options available through the health insurance marketplace. including detailed information about special enrollment rights through the marketplace. Finally, we have the Certificate of Creditable Coverage. This notice shows the start and end date of coverage for qualified beneficiaries, and it was generally provided by the insurance carrier. Because the ACA did away with pre-existing condition limitations, this notice no longer needs to be automatically provided. However, some states do require these to be made available upon request. Next, let's review the COBRA election process. COBRA has very specific timelines that must be maintained in order to avoid being out of compliance. It varies a bit depending on if the employer is using a third-party COBRA administrator like Flex. When there's a COBRA administrator involved, the employer has 30 days to notify the administrator of the qualifying event. Once notified, the administrator has 14 days to send the election notice. If the employer is self-administering COBRA, then they have 14 days to notify the QB. This is 14 days from the date of the event, like a termination for example, or 14 days from receiving notice of the event, such as a divorce or separation. The qualified beneficiary has 60 days to elect COBRA, starting from the date on the notice. Once COBRA has been elected, the QB has an additional 45 days to make the first COBRA payment. Here's how the COBRA payments work. The COBRA premium can be up to 102% of the COBRA applicable premium for each plan. In the case of self-administered COBRA, the employer keeps the additional 2% as compensation for the administration involved. If the employer is using a third-party administrator, then the administrator will generally keep the 2% as a part of their fees. Payments must be postmarked by the first of the month, and employers must give COBRA participants a 30-day grace period for late payments. Okay, now that we know the basics of COBRA, let's take a minute to talk about COBRA administration from Flex. Our COBRA administration includes comprehensive COBRA services, including preparation and mailing of election notices, payment collection, and a whole lot more. Our administration helps employers stay in full compliance with federal regulations. We offer 2 billing options so employers can decide if they want to pay a monthly fee per covered employee or instead pay per qualifying event. Our COBRA administration is fully integrated with other Flex plans, which makes everything easier for the employer. Flex's COBRA administration features include 24/7, 365 web support. Employers can add new employees and report qualifying events online. We include online reporting features and real-time account access. Our COBRA clients have direct access to COBRA specialists and dedicated customer service professionals. If you'd like to learn more about our COBRA administration or other compliance services, you can visit us online at flexiblebenefit.com or give us a call at 866-472-5351. You can also contact us at marketing@flexiblebenefit.com. I want to thank you for watching today, and I hope you found this presentation helpful. Please feel free to contact us with questions or if you need more information. Thank you very much and have a great day.